Okay, so let's get started. Hello everyone and welcome to this webinar on estate planning, probate, wills and lasting powers of attorney. Good to have you with us today. My name is Chloe Greenbank. I'm Senior Manager at Rotherham Taylor. We are chartered accountants and tax advisors, and we also provide probate services. Today I am joined by Kirsten Marshall from Admin Angels, who is our wills and power of attorney expert, and we'll be hearing more from her soon. Today we will be covering IHT and what it is. Kirsten will be talking us through wills and powers of attorney, and then I'll finish on what is probate. Like I said, we will have questions and answers at the end, so please drop us a question. So let's get started. What is inheritance tax? IHT is the tax on an estate when someone passes away. All of their assets, their cash, their properties go into a person's estate, and then the value of that is what you are taxed on, unless it falls within the nil rate band. The nil rate band is currently £325,000. So anything below this, no inheritance tax to pay. If it is over that amount, then there is potentially inheritance tax to pay. If you are passing your entire estate or some of your estate to a spouse or a civil partner, there will be no inheritance tax on the estate if it's the full estate or whatever assets you are passing to them. So no matter the value, if that's over 325,000, all going to the spouse or partner, no inheritance tax to pay, and you don't need to use your nil rate band. There is also a residence nil rate band. This is in addition to the nil rate band. It may be available if you've got a residential property in your estate, and that amount available is up to £175,000. And also the residential property must be passed to a direct descendant, so that's children, grandchildren, in order to qualify for this extra nil rate band. So what if your estate is over the nil rate band? Well, we need to apply some tax rates, unfortunately. The usual tax rate is 40% for any value over the nil rate band. You may qualify for a rate of 36% if you leave at least 10% of your net estate to charity. So you can leave that in your will, you can state that in your will, or it can be elected for after your death by the executors and the beneficiaries if they all agree through a deed of variation. There are also reliefs available and certain exemptions, so not all assets are taxable, and we'll come on to some of those a little bit later on. So what if you do have an inheritance tax liability? How do you pay the inheritance tax? So it's the executor's responsibility to pay the tax. If there is inheritance tax due, there may be cash in the estate, which usually can be used. The banks will often let you use that to pay inheritance tax if there is a liability, which is useful because the liability is actually due by the end of the 6th month after the person has died, and that is quite soon after the death, and usually don't have the probate by then. The assets haven't all been collected in and ready to distribute, so cash is needed to pay that inheritance tax. So what if there are no liquid assets in the estate? Well, there are a few different options. The person that has passed away might have taken out an insurance policy to cover the inheritance tax liability if they have been organised and prepared. The executors could possibly take out a loan to cover the inheritance tax, or the beneficiaries, if they've got some cash, may be willing to lend the estate funds to cover the liability. And then obviously once the assets are recognised and collected in and liquidated if needs be, that can be repaid to the beneficiaries. Also, the liability on any land and property can be paid in instalments over 10 years, or as soon as that land or property is sold, then the liability will need to be settled. So what can we do to mitigate a liability? Well, we have a few options. One thing we can do is to make gifts during our lifetime. Any gift we make whilst we are alive won't be taxable as long as we live for 7 years after the date of the gift. So if you've got things to give away and you don't need them at the moment, start giving them away. Any gifts to charities or political parties aren't taxable, whether that's gifted in your lifetime and you don't survive for the 7 years, or in a will. Everybody gets an annual exemption of £3,000. So you can gift £3,000 each year without it being added to your estate. So that could be in any combination. You could give away the whole £3,000 to someone, 3 lots of 1,000, 1,000 and 2,000, and so on. In addition to that annual exemption, you can also give individual gifts of up to £250 to as many people as you like, as long as you've not used another exemption on that person. So if I had gifted Kirsten £3,000, for example, I could then not gift her another £250. Gifts from income. So if you have surplus income, and if you were to make gifts out of that income and it wouldn't affect your standard of living, you could provide a regular financial gift to whoever you like, whether that's cash, whether that is the dividends from some of your shares. You could set up a standing order, and it's probably best to just have that in writing as well, just to make it clear that it is out of your income and it is surplus income. And then wedding gifts, which are exempt up to a certain level. You can gift a child £5,000 on their wedding with no inheritance tax implications. That's £2,500 for grandchildren or great-grandchildren, and £1,000 to anybody else. So that's a few tips. Then there are also some reliefs in addition to gifts. So as mentioned, if you make a gift and survive for 7 years, there is no inheritance tax to pay. But then there's taper relief. So if you die before the 7 years, there is a sliding scale of what of the inheritance tax you would pay on those gifts, depending on how long you do survive after that gift is made. There is business property relief. This relief is either 50% or 100%, depending on exactly what the assets and the business is, and they are for trading companies. There is agricultural property relief. This is 100% relief for assets used to grow crops or rear animals. There is a more obscure woodland relief for certain types of woodland. And also there's other exemptions and relief, including for excluded property and estates of people who die in service in the armed services or emergency personnel. So at this point, I'm going to pass over to Kirsten to go through wills and powers of attorney.
Thank you very much, Chloe. As Chloe's kindly said, my name's Kirsten, and my company is called Admin Angels. I was a wills and probate solicitor and have been since 2005. And over the years, I've met a number of older clients who, as a result of advancing years, they struggle with some of their day-to-day tasks. So the idea behind Admin Angels is a PA service to support those people in order that they can continue to live an independent life. In addition to the PA service, I also provide a will writing and power of attorney service, as it's what I've been doing for the last 15, 16 years. So when talking about wills and powers of attorney, it can be beneficial to address the topics in the order that they would be used to try and prevent confusion. So let's start with lasting powers of attorney. When I first qualified as a solicitor in 2005, enduring powers of attorney, or EPAs, were the documents that were available to clients at the time. They were a relatively straightforward and easy to produce document, but it was felt that their simplicity was their downfall, and therefore too open to abuse, and they needed to be overhauled. So they were transferred in 2007, and that's when we were introduced to lasting powers of attorney, or LPAs. The enduring powers of attorney only ever related to property and financial affairs, and it's worth pointing out here, if you have an existing EPA, provided you're still happy with your choice of attorneys, then it is still valid. But when the LPAs were introduced, they came in two formats: property and financial affairs and health and welfare. Health and welfare were a wholly new concept at the time, and they're still currently finding their feet as to how and when they can be used. The theory behind both powers of attorney is that you're making an advanced decision and appointing somebody to act on your behalf if you're unable to do so. The major difference is that a property and financial affairs power of attorney can be used at any time if you give authority, whereas the health and welfare can only be used once you lose capacity. They are both separate forms, independent of one another. You can make one without the other, and you can have different attorneys on the two different types of powers of attorney. So by having a property and financial affairs and a health and welfare, that demonstrates that you're able to have two types of powers of attorney running concurrently, but covering different areas of your life. And this is a particular benefit to people who are business owners as well. Although you might be quite happy for your spouse or children to have control of personal finances, you may want somebody with a greater understanding of your business to be able to control your business dealings if you're temporarily incapacitated. If you're a shareholder, one of multiple shareholders in a company, or one of two partners in a company, you might feel that your business partner is the person with the greatest understanding of your business and therefore is best placed to be your business attorney. However, if you and your fellow business owner have different views as to the future of the company, what you don't want is them to take advantage of any accident or illness that you may have to steer the company in a direction that you wouldn't agree with. So you need to give potentially some very careful thought to who your business power of attorney would be. So it's quite possible to have three powers of attorney. You've got your health and welfare, a personal property and financial, and then a business property and financial affair power of attorney, all running at the same time. Ultimately, powers of attorney have been likened to house insurance. It pains me to pay for it and buy it at the first instance, but it's good to know that if you ever need it, you can open the drawer, take it out, and the document is there to be relied on. The upside to house insurance is you don't have to pay for it every year. Once you've paid for it, that's it, and it's done. So a power of attorney only has any validity whilst you're alive. On your death, the power of attorney ceases to have any authority, and that's when your will then comes into effect. You may have the same person as your attorney and your executor, and that gives continuity to make life easy for those left behind, but it's not necessary. Will writing is without doubt on the list, everyone's list of jobs to do, but understandably quite frequently gets kicked to the bottom of the list. And most people do say to me, I've meant to do it for years, I've just never got around to it. But, you know, there's many reasons why you should make a will, but I would say experience has taught me that there's three reasons that people finally get around to actually doing it. The first reason is the protection of vulnerable people. Vulnerable people come in many guises. So those with young children, first and foremost, should make a will. Many reasons for doing so. One is to stipulate the age at which you think your minor children should inherit at, particularly if you feel that the statutory age of 18 is too young. Secondly, your will can then appoint executors. They're the people who will be responsible for managing the funds till your children get to the age that you've stipulated. And thirdly, for the appointment of guardians, and they're the people that manage your children and look after them if there is nobody with parental responsibility left living. Similarly, parents, so elderly people, your parents may be part of a generation that have found their house prices significantly increased. And therefore, as Chloe's mentioned, inheritance tax might be something that's an issue to them. If they were to inherit from your estate, you might be adding to a nightmare of a tax situation that they've actually already got. So simply by making a will, you can skip the older generations and leave your estate down to younger generations and avoid any tax problems from there. Anybody with a disabled member of their family, and particularly children, should without doubt consider making a will. Firstly, because the disabled child is unlikely to be able to manage wealth of any size, and therefore if they were to inherit, the next thing that would have to be done is a deputy would need to be appointed, and that's quite costly and quite time consuming to do, and the cost is ongoing. But secondly, a disabled child is likely to be living from benefits, and by inheriting your wealth, that would knock out their entitlement to receive benefits. So by carefully managing inheritance, you can retain a right to receive those benefits, but use the inheritance to add to the quality of life that the benefits provide. Similarly, anybody with a drink or drug addiction, or potentially even a shopping addiction, should have their inheritance managed on their behalf, and all of that's possible through the use of trusts within a will. And finally, if you have a child or another beneficiary of your will who is married but separated, or maybe the relationship looks a little bit rocky, then it's a good reason to make or review your will. If the beneficiary is to inherit and then subsequently divorce, those inherited funds would be part of the assets divided during divorce proceedings. So it is possible to ring-fence assets to ensure that they only pass on once the matters have been resolved. The second main reason that people get around to making a will is because modern living and wills just aren't cohesive at the moment. The format for a will is that's currently drafted in England and Wales is governed by the Wills Act of 1837. And for those who don't get around to making a will and die intestate, you're governed by the Administration of Estates Act of 1925. So the two statutes, although they've been revised, the laws are significantly out of date when you're thinking about taking into account modern families. Your classic situation is two parties who've chosen to cohabit or remarry, but both or at least one have children from a previous relationship. You'd therefore want to make provision for your new partner, but whilst ensuring that your wealth ultimately passes to your own children. And only by making a will can you ensure that this happens. And then this is very similar to your third issue, which is asset protection. The days of fancy and expensive will drafting to protect people from inheritance tax are predominantly behind us. The many loopholes have been closed, but as Chloe said, at the same time, many tax reliefs have been increased or introduced, like the residential nil rate band. So it's wise still to talk to your legal advisor to ensure that when you're drafting your will, you are making the maximum use of all those reliefs that are available to you. But one area that does remain a concern to many clients is the issue of care home fees. And many people ask about how to protect their assets from the vast cost of care if it's needed in the future. It's worth pointing out that it's easier to plan now whilst there's two of you, rather than waiting until all the assets have been inherited by one party, because at that point your options are significantly reduced. So the sooner you start talking about it, the better. Please bear in mind that transferring your house now to your children is one of the riskiest things that you can do. It's one of the most commonly asked for things to do, but there are many other things that you can do. And again, it's all about talking to your advisor to make sure you're doing the right thing. They do say that a will is your final gift to your loved ones, and that you do not know the true cost of making a will until you don't make one. Strongly recommend that you do make a will. And if you're currently sat there feeling a little smug and thinking it's okay, I've already done mine, it's worth getting it out, dusting it off, rereading it, and ensuring that it still reflects your wishes, but also running it past your advisor to ensure that it's up to date with all the current regimes and practices, particularly with regards to inheritance tax. That's all from me. Thank you very much.
Thanks, Kirsten. That was really useful. So we'll just move on now to what is probate. So if somebody does pass away, what happens next? So probate is the legal and financial process of dealing with the estate of a person who has died. Like Kirsten mentioned, whether they're appointed in a will or through because there is no will, there will be executors, personal representatives who have responsibilities. Those responsibilities include collecting in the assets or determining what the assets are to start with and the liabilities, paying any liabilities and expenses, and then distributing the estate to the beneficiaries. They're also responsible for applying for the grant of probate or the grant of letters of administration if necessary. So the grant of probate or letters of administration are required when somebody owns property in their sole name. So it's not owned jointly, it's not going to be passed direct to their spouse or civil partner. A grant is needed then. Or if somebody asks for it. So a bank, for example, if the person that's passed away holds quite a chunk of money in a bank account, the bank will often ask for a grant of probate. Or if somebody has investments that held by a broker or something like that, they will often ask for a grant in that situation too. So moving on to the actual process of probate and how we get that grant. A lot of people know the term probate, but they don't actually know what it entails behind the scenes. So we'll just go through a simple step-by-step plan here. So step one, as mentioned, identify all of these assets, liabilities, determine the value of the estate, and review the will. This can often require a bit of investigative skills. If a lot of us don't like to talk about death, like Kirsten said, we don't want to talk about our wills, we leave it to the last minute, something we put off. So we don't always know what our family has in terms of assets and liabilities. We actually have a useful checklist which we can send out to everybody, where you can just keep all your useful information together, and then that can be kept with your will, and is really useful for your executors when it comes to that point. Yeah, so that's the first step. Step two, pay any inheritance tax due to HMRC, submit the paperwork and apply for the grant. Step three, once the grant is issued, start to liquidate the assets if need be to repay people you might have borrowed money for to pay the inheritance tax, settle any liabilities, pay any expenses that are still outstanding, and prepare estate tax returns to declare any income that the estate has received whilst all the assets are in the estate. So that might be a rental income from a rental property, for example. Step four, the estate accounts. So once everything is settled, we do the estate accounts. That needs to be approved by the executors. And then final step, distribute the assets. Like I said, that is a very simple process and just gives you an idea of what is involved and what to be prepared for. In theory, or in practice, it can be a lot more complicated and is a bespoke process for each estate. So hopefully today has given you a simple insight into the probate process, the importance of wills and powers of attorney, giving you some tips on how to save inheritance tax. As Kirsten has explained, she can help you with all wills, powers of attorney, so please do get in touch with Kirsten if you've got any questions there. Rotherham Taylor, how can we help? We do a lot of inheritance tax and estate planning, how to save inheritance tax, mitigate the liability as much as possible, what are the best structures for your investments, for your rental properties, for your businesses, and work out any potential liability that would be due on your estate. We can also help with the probate and estate administration, whether that is a grant-only service, applying for the grant, corresponding with HMRC, calculating the inheritance tax that's due, or we can do full administration. We can hold the executor's hands from beginning to end and help with the whole process. So let's move on to questions and answers. We have had a few questions in advance, so let's tackle a few of those for you. So Kirsten, a question for you firstly. How many executors can I appoint in my will?
You can appoint as many as you like. There is no limit, and there is no hierarchy either if you appoint more than one. So it's not a case of I'm the first appointed and everybody else is subordinate to me. You can have more than one. The only thing we would say is it generally gets a bit more complicated the more you appoint, because everyone would then need to start signing like closure forms, sale forms, contracts for sales of property, etc. And particularly if you spread around and about, it can make that even more difficult. So way modern families are, no one all lives in the same village any longer, so it can become more complicated. But also ensure that when you do appoint executors that they all get on, because if you don't have executors that get on, your estate will never be administered and progress will stall. So make sure you have good executors who can work well together.
Yeah, we definitely don't want that. It takes long enough as it does without complications with the executors. So next question, I'll take this one. So for the charity relief percentage to apply, can you donate to more than one charity? The answer to that question is yes, you can do. You can leave, as long as it's 10% of the net estate, you can leave it to as many charities as you like. It is just worth checking they are registered with HMRC, as that is what needs to be, they need to be registered with HMRC in order for the relief to qualify. So next question, Kirsten, will come to you again. Why do I need to make a will if I don't have any money?
It's quite a good question. Again, it comes back to, particularly if you've got minor children, executors and appointment of guardians, and guardians more important than ever. If you have a guardian appointed in your will, the will is effective immediately on your death, and therefore the appointment of a testamentary guardian it comes into effect immediately. That will comes into effect, rather than somebody having to go to a court to apply to become a guardian of a child of somebody who's passed away without a will. Also, if you've got two spouses and maybe one is more asset rich than the other, a lot of husbands, for instance, say, I need to make a will, but the house is in my name, etc. But she doesn't need to make a will because she doesn't own anything. And you say, but who are you leaving it to? And if he's going to leave it to her, then she needs to make a will as well to then pass it on ultimately. So she might not have anything at the moment, but that may change in the future. So don't just judge it as it stands today, think forwards as well.
Yeah, really important. Next question. So what if you don't use all of your nil rate band? Well, I can say if you don't use all of your nil rate band, it can be passed to your spouse or civil partner, any unused nil rate band. So you might use a little bit of it, you might use all of it, or none of it, sorry, and anything that is unused can be passed. And the same goes to the residence nil rate band, that can also be passed to a spouse. So in theory, between a couple, they could pass £1 million of assets to a direct descendant with no inheritance tax implications. So something to bear in mind, both for your inheritance tax and estate planning and for your will writing, to be strategic about it, I suppose. Next question. Kirsten, can I include funeral arrangements in my will?
You can, and it is something that would generally be asked of you if you want to include anything. But if you do, it is generally only classed as a wish if it is in your will. Your executors still have control to do whatever it is they wish to do so. Simply including directions whether to be buried or cremated, and then possibly a little bit further about in a service or what have you. But if it's more complicated than that, and I've received some very strange requests in the past, I would generally say do that as a side letter to your executors. And the reason being, because if you do go through the probate application, as Chloe pointed out, your will then becomes a public document. So you might not want too many details of your funeral to be involved in that public document. So things like choice of music, flowers, etc., possibly do more as a side letter to your executors. But it's always worth doing it, because when your advisor asks you now and you're fit and healthy, you might think, oh, it's fine, I'll just tell the kids later on what I'm going to do. But they've got a number of years to be told and then forget. And you've got to remember that at the time when they're sorting out your funeral, they're grieving as well. And they might forget what mum or dad told them 20 or so years ago. Whereas if it's written down in black and white, it is a good reminder to them.
Definitely. And I suppose that would be a good thing to include within the pack that we're saying to keep, and make sure family members do know where that is kept for when the time comes, because sometimes it's not always known when that's going to happen. It can be obviously a shock. So I think last question for today, would my rental property business qualify for business property relief? Unfortunately, rental property businesses are classed as investment businesses by HMRC, and business property relief is not applied to rental property businesses. But if you do have any circumstances like that, please do discuss with us what you've got and whether the relief would qualify, because obviously there's different levels of relief, and depending what the assets and what the business does depend on whether that relief is available. Right, so like I said, that was our last question for today, but thank you very much for joining us. We hope you found it useful. Kirsten, thank you so much for joining us. Some really useful information there that I know I'll be taking away personally myself. So thank you for that. If anybody does have any further questions or wants to get in touch and see what services we can help you with, please do. All our details are there on screen. We are both on LinkedIn if you would like to add us there. So yes, thank you very much again everyone for joining us, and hopefully we'll see you all soon.